barakatuh. Assalamu alaikum. Thank you for joining my show, Law in Action, on Ramadan FM. I am your host, Zainab Zaeem-Sattar. So it has been a while, a couple of months, for me to bring a Law in Action guest, and I'm quite pleased to be here tonight in studio with my guest live. So no Zoom logins, no recordings. We have a live guest. So this is a new experience for me. And we have tonight Dilshad Miah of Family Law Mediation. So before I introduce Dilshad to our listeners, I do want to explain that this show is interactive. You can telephone the studio line. You can WhatsApp in on, so the studio line is 0116 4822 The WhatsApp is 077488 55055, or you can chat through Facebook on Ramadan FM. So, without further ado, I would like to take this over with Dilshad Miah. Assalamu alaikum, Dilshad.
Wa alaikum assalam, and thank you, Zainab, for having me on your show.
You're most welcome.
So yes, I'm a solicitor and I'm also a family mediator. I've been working in the area of family law for the last 16 years. And in my life as a solicitor, I specialize in areas such as private law children matters, domestic abuse, divorce, property and finances. I've also retrained and become an accredited family mediator. And then what that involves is rather than me helping people through the court process, I try and help them stay out of the court process, and so help people reach agreement regarding children matters, property and finances.
Okay, well, you've gone and answered the first question I was going to ask you. The first question I was going to ask you is, before we actually delve into the world of family law and mediation, can you briefly explain what family law actually is? You've kind of answered that. So it deals with family matters, divorce, domestic violence, but can it also include things like custody issues, financial issues to do with, say, property, assets and things like that as well?
Yes, absolutely. So family law is actually a huge area, and it does cover things like child arrangements, like you've mentioned. It also includes things like divorces, property, finances, domestic abuse. It also encompasses areas such as cohabitis disputes. So people don't necessarily have to be married for the term to fall under family law. So we deal with cohabitis, grandparents as well, who wish to spend time with grandchildren, for example. So it covers a whole host of areas. Family law as well also encapsulates public law matters, so where social services are involved with the family for various reasons.
Okay, so it kind of mixes in, gels in, and you'd liaise with them as well. Okay, so it's quite a sensitive area. I can imagine sometimes your day wouldn't be the easiest of them all, would it?
No, not at all, because as a solicitor, going into the office, I can have, say, like in my diary, various things and tasks that I will do, but then you might get an urgent call from a new inquiry saying that they need an urgent injunction, to protect themselves from domestic abuse, or they need an urgent court order to stop a child from being removed from the country, for example. So everything in my diary, tasks and things, might go up in the air slightly, and that's when the team would kind of all kick in.
I can imagine, quite a scary time. So before I continue with any more questions, what I do want to say to our listeners, that although tonight's show is family law mediation, it is a very sensitive area. And by bringing you this type of show, it's in no means meant to offend anybody. It's there for awareness. It's a very important issue that needs to be discussed. Many times, and I'm not saying this is everybody, but many times, and I've seen this firsthand, some of the issues, especially our Asian communities that encounter, do get brushed under the carpet. You will have, say, a mother or a father or an uncle or an auntie or a brother say, oh, let's not discuss that. we don't want to know that, or it's got nothing to do with you, or forget about it. Any number of those things. So when we are discussing this topic tonight, it's purely for the awareness. It's to let people know that actually there is help out there should you need it. And in fact, you should seek assistance. You shouldn't rely on, say, your next door neighbour's knowledge, because whilst they may have a lot of experience, their knowledge in the law, if they're not a solicitor or an accredited mediator, their experience, their knowledge will be very limited and might not even be the correct advice as well. And it might get you more into hot water than it actually does to aid you as well. So now that I've explained that to everyone, you said that you're a solicitor, but you've also retrained and become an accredited mediator. Now, for anyone who missed it before, a mediator is where you try and negotiate and you try to keep people out of court. But isn't that what a solicitor does as well? I mean, I'm a solicitor, and as a litigation lawyer and an employment lawyer, the first thing I want to do is to make sure that court is the last resort. So what exactly is the difference between the two? Can you explain that, please?
Sure. So with mediation, it's a more friendly way of resolving disagreement. So if, say, for example, I take the scenario you've given, where you say you try and keep people out of court, through mediation, I would, before the pandemic, would sit down in a room with the separating couple, and that's where we would talk about what the issues are. And then we would discuss options around ways of settling the differences the separating couple might have. So in this scenario you describe, you might be corresponding with the, say, other solicitor and negotiating a settlement of some sort. Whereas with mediation, the parties are often in the same room as each other. So, like for example, it might take you some days to write a letter to, your opponent, and then your opponent would have to take instructions from their client and then revert back to you, which might take a couple of weeks. Whereas parties, when they're in the same room as each other, they listen to what the other person has to say, and so they can get an answer to the issues that they've come to mediate about there and then. So the difference between going to a solicitor and a mediator is that in the mediation process, it's the people who are actually talking to each other about what the issues are, whereas with a solicitor, it'd be you writing on behalf of your client to the other solicitor.
Okay, understood. I got you. Thank you so much for that clarification. I mean, one of the things I often get told to me when I'm a solicitor, oh yeah, you're a lawyer, all you care about is the money aspect. But people actually forget that whilst, of course, we want a salary, when that's not the only thing we're there for. We're there to help people as well as much as possible. Mm-hmm. Thank you very much, Akil. Sorry about that, listeners. We just had our producer come in for a few seconds. In terms of what it is that you do, now you said that you sit the people down. Now I'm picturing a scenario here where you've got, let's say, maybe, I wouldn't say an abusive relationship, because when you've got an abusive relationship, I'm assuming you wouldn't put those two people together in the same room, because you're going to try and avoid hurting whoever the abusee, the person who's been abused, the victim. So if we move away from that element, but I've got a picture in my head where you've sat a couple down who might be on amicable terms but don't know how to kind of split the assets and that. What are the challenges that you might come across when you are mediating in that scenario, as opposed to being in a courtroom where you've got a judge? Because with a judge, people have to be quiet, don't they? Everyone gets a turn. It's a bit like being in school. But when you're actually mediating, it would be more of an informal environment, slightly more relaxed than a courtroom. What challenges, if any, do you come across?
Very good question there, Zainab. I'll break that into compartments, if that's okay. So first of all, you mentioned there's the issue if, say, for example, there's been some domestic abuse. So before we go into a mediation, let's just say in this example, there's a husband and wife, and then one of them has been the victim of domestic abuse. Before we put or agree for a mediation to take place, there would be something called a mediation information assessment meeting, which is commonly referred to as a MIAM. Now, that meeting is a one-to-one meeting between me and the other person. So, for example, I might speak to the wife first on a one-to-one basis, and then after my conversation with the wife, I will have the same conversation with the husband on a one-to-one basis, so individually. And during that conversation, I will screen for domestic abuse to see if there are any allegations of domestic abuse. So I would ask questions to see how they would feel sitting in the same room as one another. I mean, now we're doing mediation via Zoom and Microsoft Teams like that. So at the moment, they wouldn't necessarily be in the same room. They could be in different sessions. So what I'm trying to say is we wouldn't say that they start the mediation in the same room if there has been evidence of domestic abuse, or it might even be that there hasn't been domestic abuse, that the wife might not necessarily want to be in the same room as the husband and vice versa. So under those circumstances, we would offer them something known as shuttle mediation. So if we're doing mediation physically, so in the same room, then we would put the husband in one room and the wife in a separate room. And in that mediation, the mediator, so me or one of my team members, would go from one room to the other room so the husband and wife don't meet each other. If we're doing a similar thing via Zoom, for example, the wife will be in one Zoom session with me and the husband will be in another Zoom session with me, so they don't necessarily meet each other. Now, the beauty with the whole mediation setup is that the parents or parties, clients, they are in control of the mediation. So it might be that in the mediation assessment meeting they say that they don't want to be in the same room as each other, but then come the mediation, maybe they'll say they do want to be, and it works the other way around as well. So if the session starts off in the same room, they can at any point say, oh, I'd like shuttle mediation. So that's how I deal with the issues of domestic abuse. If it is a issue that one of them raises, and that's how we deal with them. Now, with the whole court setting, that's completely different in the sense that the husband and wife, again, in the example that I'd use, might be in a room with the solicitors or barrister with a judge, where a judge will make a decision for them, whereas in mediation, there's no stranger making a decision for them. Accepted, the, say, husband and wife will have a mediator in the room with them, but the mediator doesn't make a decision for the couple. It's the couple who make the decision.
So they're in control, literally. I mean, being in a courtroom, once you've presented your case, so one partner presents their case, the other partner presents their case, but ultimately it is the judge's decision. And sometimes that decision is not always going to be in your best interest, because especially if there's a child or children involved, it may be in the best interest of the child. Now, I don't deal with family law, so I'm not actually quite clued up with how family law works. And there's a reason for that. Actually, I did get asked a couple of days ago, why do I not want to do family law? And there's a number of reasons. A, I don't think I've got the patience for it, because you have to be quite sensitive. And whilst I can be a little sensitive, I don't think I am too much, if that makes sense. I'm quite firm, and sometimes because I mean, you can naturally gauge the tone of my voice, everyone's normal tone is nice and calm and gentle, whereas my whisper comes across. Like my whisper is not a whisper, it's a normal human being's tone. And when I speak normally for me, for somebody else, and I've been told this on many occasions, is quite aggressive. So I don't believe I'm the right person to do family law. I do litigation, and I think that's the perfect area for me. And, kudos to you for dealing in this area. Now, we mentioned mediation, we mentioned court. What we haven't actually mentioned is who is the independent party here in terms of the mediator. And let me explain that a little bit more. When people have a solicitor, and we're assuming that people are instructing solicitors and they're not lay people being they're just representing themselves and they don't actually have a legal representative. If they do have a legal rep, they've got party A, so let's say the husband, he's got a solicitor, and the wife, she's got a solicitor. So they both instruct different solicitors. You can't have one solicitor acting for them both. But here as a mediator, and I really want the listeners to understand the difference, with a mediator, you're an independent party, aren't you? So you are not obligated to the wife and you are not obligated to the husband. Your first duty is to the court. Am I correct when I say that?
So, yes. So, as a mediator, we're not there to advise the, say, couple. So, let's take the example of the husband and wife again. Yeah, correct. Sometimes they will have their own solicitor, and they'll come to mediation. So, it might be in the mediation session. Let's take property as an example, that the husband and wife have agreed that they're going to go 50-50 on the house, and that's what they've agreed in the mediation. So following, during the mediation session, I will have assisted them to explore all the options available as to how they can reach agreement. And once they reach agreement about, say, the 50-50 split, I can't actually advise them about whether this is a fair settlement or not. What I will say is I will write up what's been discussed, and this has been agreed, and each of them should always go to their own solicitor and get independent legal advice. So as a mediator, I always say to my clients that you should always have a solicitor in the background, because as a mediator, I can give you information. So I can probably say what you are discussing and agreeing with your husband and wife, for example, is within the range of orders a court can make, but I can't give them advice. They would have to go to their solicitor for the advice, and the solicitor will say, yes, this is a good agreement, or no, go back to mediation and see if you can agree on X, Y, and Z, taking into account the advice that the solicitor will have given them.
Okay, thank you very much for that, Dilshad. I appreciate you making that clarification. Now, I'm pretty sure our listeners probably want to know a bit more about costs and what the costs are involved when it comes to mediation. Now, I remember when I reached out to you to invite you on to my show, you did mention something about I could be completely wrong, so I'm going to hand this over to you, but you mentioned something about costs being paid or some costs being put towards mediation by the courts at the moment. Do you want to give a bit more of the explanation?
Yes, the government voucher scheme.
You remembered.
Yes. Yes. So there are various ways mediation can be funded. The first and probably the most common is people pay privately. And the other way is people who are eligible financially, they will get legal aid. But the government at the moment is really pushing mediation because I think the pandemic has probably identified or probably exacerbated the problems we have with the court system at the moment. So, I mean, if, say, for example, somebody makes an application to court, say, regarding finances, those matters aren't being prioritised at the moment within the court system. So the parties might be waiting several months before the matter is even listed for a hearing. In my role as a solicitor, we submitted an application probably a few weeks ago, and we're still waiting to hear from the court to process it. So the whole mediation route is a lot cheaper than going through the court process, but the scheme you're talking about is the voucher scheme that the government has got in place at the moment. And the way that works is the couple who want to go through mediation have to attend a MIAM, a Mediation Information Assessment meeting, and then following on from that, if both of them agree that they want to mediate, then the mediator can apply for a voucher from the Family Mediation Council, which has a value of up to £500, and that will pay for the mediation sessions. Okay. Often it's probably about 2 sessions. And so that voucher scheme isn't means tested like legal aid is. So yeah, the government is really driving mediation at the moment.
Well, I can imagine there must be a backlog of cases. I mean, I know as litigation and employment lawyer, there's a massive backlog of cases with courts, and we are waiting, several months before we've even heard back from the courts. And often it's, us who have to chase the courts and find out what's going on. Now, before we move on to the next question, as I said to you at the start, before the show started tonight, I've actually had a message come in directly. Now, I mean, I don't know about many of my listeners, but I know some of my friends. There's always somebody that that is going through either a separation or a divorce. Unfortunately, we are now living in a day and age where it seems to be on the rise. Whatever the reasons, I'm not here to start getting into what those reasons are, but I guarantee you somebody will know somebody who's been through a separation, a divorce. There's been issues with childcare, issues with finances, but it's not just issues where the child is involved. There might just be issues when it comes to assets or, property. So the question I've now got that came to me directly is, I know somebody who, husband and wife, bought a property in 2016, and up until about 2019, the husband was paying the mortgage, or majority of the mortgage, but the wife contributed 75% of the deposit for that house. Now, he's up to left, and she's now paying the mortgage herself for 2.5 years. Now, there's a financial hearing coming up in December where the judge will decide the share of the ex-husband and when to give it. Now, her question is, she's recently remarried, okay, but her current husband, her new husband, is not paying anything towards the house. It's got nothing to do with him right now. So will the fact that she's remarried impact the hearing financially for her if she discloses to the court that she's married? That's one. And second, is she obligated to disclose to the courts that she's remarried if it's to do with the house and the fact that she's been paying the property?
Yeah, so I mean, to answer a scenario like that, I'd need a lot more information because there's a whole host of things that's going on in the scenario that you've described. But speaking generally, because she's in a court process, she is under, and both of them actually are under a duty to provide the court and the other person with full financial disclosure. So in your scenario, if she has married, then she's going to have to disclose that. As to what share she might get or what share her husband might get, that's a very difficult question to answer because,
I understand.
We obviously need to know the full ins and outs as to what the assets are, et cetera, et cetera. But I think what I would say is under Section 25 of the Matrimonial Causes Act 1973, sorry to go into so much detail here.
I can't believe you remembered. I barely remember any legal acts. Go on.
I've been doing this for 16 years. So, so yeah, under that act, there's a whole host of things things a court has to consider, a judge has to consider before they make a decision about what the judge is going to order regarding the assets. The first foremost is what's going to be the children's living arrangements, and then there's all these other things that they will look at, like how old the parties are, how long they've been separated, what their income is, what their outgoing is, and I think in the scenario you're describing, if the wife has remarried, then really it depends on who started the divorce proceedings, because that could create complications for her if she was the respondent. But like I say, I don't think I'm in a position to give specific advice. I can talk around the issue because there's a whole host of things a judge will look at before.
Just to interrupt in that, I mean, you mentioned quite interestingly, it depends upon who's initiated divorce proceedings. I'm so glad I don't do family law, honestly, because for me, it would be a case of, well, forget who initiated the divorce proceedings. What about the person who actually left the relationship?
No, oh, sorry, no.
Do you see what I mean?
What I meant with that is, if she's the respondent in divorce proceedings,
and respondent being
the person who didn't start the divorce proceedings, and she's remarried, that could have implications on the whole application as to who made the financial application. So it's in that context. The courts don't really distinguish between who the petitioner is, the person who starts it, and who the respondent is. But in the scenario you're describing, if she's remarried and she wasn't the person who started the divorce proceedings, then she should seek legal advice. Okay.
Well, you heard it here then. I'm not going to mention my friend's name for anonymity, but if you are listening, I have asked you a question and he has answered. So if you need further advice, then if you've got a solicitor, please reach out to your solicitor, or by all means, please do reach out to Dilshad. I will be sharing his contact details towards the end of tonight's session. So before I start bombarding you with any more questions, Dilshad, I know that you've come tonight prepared with some notes about family law and mediation itself. Is there anything that you wanted to touch upon that I've not touched upon and I've not covered? If there's anything that you want to discuss, now's your time.
Yeah, I think one question that I'd like to probably elaborate on is what actually is family mediation. So family mediation is a conversation between, say, separating people. It can actually involve grandparents as well. So it involves a whole range of family scenarios where people would sit, well, sometimes in a room or in a Zoom conversation, and talk about the ways they can co-parent their children or reach agreement regarding property and finances. Now, mediation is a lot friendlier, can be a lot quicker and a lot cheaper way of resolving these issues with the other person. The idea of mediation being that at the end of mediation, there's an agreement between the, say, separating couple where they sign, for example, an agreement which will state, for example, this is when the children will spend time with the mother and this is when the children will spend time with the father. So it's in a document which they've both agreed to, which is different to going down a court process because it's going to be a judge, a stranger, somebody else that's made the decision for you. Mediation can also be used in a situation where, for example, you've had an agreement in the past about your children, for example, but as they get older, their needs change and the family dynamics change. So you might come to mediation to talk about previous arrangements which have been in place and they just need tweaking or altered, and mediation provides a space for, say, the husband and wife, or I keep saying husband and wife, but it can be cohabiting people as well. And mediation provides a space for the people to come together to discuss what the issues are, with a view to them reaching an agreement. And the biggest advantage of mediation is you're in control. So if you decide that, you don't want to carry on with mediation, for example, or you need a break, we can facilitate all of that. Whereas once you're in the court process, it can be quite difficult to get yourself out of the court process. So, like I say, mediation, you are in control. It's, I think, fair to say, it's a more fairer, friendlier and dignified way to separate and reach agreement with your ex-partner. One thing people confuse mediation with is they think they will come to mediation and we will encourage the, say, cohabiting couple or husband and wife to get back together. So mediation isn't a service where we would encourage people to get back together. That's probably more marriage counselling. People come to mediation where they've decided, that's it.
Enough is enough.
Yeah, I'm not in a relationship with this person, but we need to sort out the arrangements regarding the children and property. So that's when they would come to mediation. I've touched on grandparents because I do often, quite often get grandparents who haven't spent time with their grandchildren. So we'd invite the mother and the father of the child to attend mediation with grandparents as well.
I'm glad you mentioned grandparents because often in these type of scenarios, uncles, aunties, siblings, older siblings, grandparents, they can get lost because when the mum and dad are fighting, when husband and wife or, like you said, cohabitees are fighting, everybody else, it's collateral damage, so to speak. Now, when we talk about cohabitees, what cohabitees is when there's a couple who are in a living relationship and they may or may not have children, they may or may not have property together, but they're living as boyfriend and girlfriend under the one roof, then they're not married, so they're known as cohabitees. Now, there's a whole other topic as to what cohabitees' rights are here in the UK, and a lot of people do get mistaken, especially when there's the misconception that if, say, a Muslim couple have done their nikah, they're married. Well, yes, you are in the eyes of all the other Muslim beings and in the eyes of Islam. And in front of Allah, you are married. But in the eyes of the UK British law, you are boyfriend and girlfriend living under the roof. You are cohabitees. You are not married couple unless and until you do the civil registry. And I'm talking about the UK. I'm not talking about if you've been abroad and you've done the registration of your marriage there and then you've come over here. I'm not talking about that. I'm talking about here in the UK. So your actual rights as cohabitees is very different. But like I said, that is a completely different topic. And, maybe one day, Dilshad, you could come in your capacity as a family solicitor and we could discuss that. Tonight's about the mediation aspect of it. Now, when you did mention grandparents, I do want to highlight the importance of a grandparent in a child's life, as long as your child is safe with that grandparent. But my eldest son, he's 20 now, so I do get to call him my eldest son. He absolutely, loved his paternal grandma. And there would be times where if we were dropping her off to the airport to go India or something, we got kicked out by security guards because he bawled, cried on the top of his lungs because he just did not want to be separated. But when I went India a couple of months later, the young lad was just like, bye, Mom, and, waving with a smile on his face. So you could tell the difference of the love there. And when me and my ex separated, one of the first questions I asked my son was, and he was only about 13, 14 at the time, I said, who do you want to live with, me or your grandma? And he was like, well, 50-50 grandma. And I went, go for it. And I absolutely wholeheartedly let him go between the two houses if he wanted to live with her, 100% with me, whatever he wanted, because I was not about to stand in the way of their love, their bond. And also, no one's going to be able to take away the fact that I am the mother. That's it. I'm the mum. No one can take that away from me. So why stop grandparents from seeing the children? And more often than not, I do see these situations occur where the father won't let the maternal grandparent see the child out of spite and vice versa. And people do forget in all of this that there are kids involved, there are human beings involved, whether that's mother, father, grandparents, siblings and things like that. So if you do know somebody who's going through a separation, a divorce, and it's acrimonious, someone, chances are you probably will, and the court process is not for them, talk to them about mediation. Let them know that there is such a thing as mediation. Point them in the direction of Dilshad Miah, or point them in the direction of someone else who you think is more suitable. Completely up to you. You're not obligated to come to us because we brought this show to you. What I'm trying to highlight is it's very key that everybody seeks legal assistance, whether that's by solicitor, whether that's by an independent mediator. It's essential in order to maintain also it's mental health and well-being, the amount of stress a person can go through. And the other thing I wanted to touch upon, and this is to the men out there, and I mean no offense to any of my listeners here, a lot of the times the men get forgotten. When the woman takes over and it's all of her demands and all of her needs are met, the man's need gets forgotten. There might be a man out there who wants to see his child, who might not care about the property, probably just wants access or custody of the child. Do remember that men and women have feelings, So do try and seek that legal advice and get counselling if you need to, but don't do it yourself, certainly. Now, before I continue to ramble on, Dilshad, while you patiently sit there and listen to my voice, we've got about 13 minutes left, and if you've just tuned in, you are listening to Ramadan FM, Law in Action, with your host, Zainab Zaeem-Sattar, and I have Dilshad Miah from Family Law Mediation with me tonight. Now, you touched upon legal aid. Talk to me as if I'm clueless.
Yeah, so legal aid is a complex area.
Oh, yes.
To say the least. Okay, so let's talk about family legal aid. Okay, so one advantage, if I can call it that, is to get legal aid for mediation is slightly easier than getting legal aid for a family law matter. Now, I'll just distinguish the two. So mediation, like I say, is where you have a conversation with a mediator to see whether you can reach agreement about, say, children, property and finances, whereas family, if you were going to a solicitor regarding family matters, you would instruct them to act for you, say, for example, for your divorce, or make an application to court for a child arrangement order or financial orders. So to get legal aid for family, you need to show that you're on a low income, and usually that means you're on one of the passported benefits. So nowadays you get, say, a lot of people on universal credits as opposed to income support. So that's the most common one I hear nowadays. And the thing I think people forget is that just because you're working doesn't mean you're not going to be eligible for legal aid. I would say you can go on the .gov website or even the legal aid agency website, and there's a legal aid calculator where you could put in details about your income and your the certain allowances, so rent, mortgage, and certain other things, and the calculator will give you an outcome at the end of the calculation saying whether you're likely to be eligible or not. Or you could ring a mediator who does legal aid mediation work, and they'll do an assessment for you. But the biggest difference is, to get family legal aid, you need to A, be on a low income, and B, show, well, usually, depending on the type of order you're applying for, that you've been the victim of domestic abuse. Whereas for mediation, you don't need the evidence of domestic abuse. So that's probably the biggest difference in the legal aid system. But it is quite a complex area, and if I go into it any more details, I think I'll just put you to sleep, if I'm honest.
Well, we'll definitely need longer than the 10 minutes that we have left remaining on the show. Now, you mentioned means tested. Now, when you say means tested, I take it you mean when we're on one of those benefits like universal credit or something like that. So when you apply for legal aid, and I'm pretty sure you mentioned earlier, it's not means tested.
No, so legal aid is means tested, but the government's voucher scheme, that's different to legal aid. That isn't means
I'm glad
tested.
you clarified that, because I hope my listeners understood the clarification. I just wanted to make sure, just in case I got that bit wrong. Okay, so brilliant. Now, you're a solicitor and you're an accredited mediator. Say I was your client and I came to you, say I was a person and I came to you, me and my ex, me and such a person came to you, and we said we wanted to use your services as you being an independent mediator. What would my obligation be? A, either to you, or B, to my ex-partner who's there as well. Do I have any obligations?
Obligations in what sense?
So let's say, for example, the best example I could give you was the scenario I gave you earlier when my friend asked a question. You mentioned that we're under a duty, there is an obligation to let the courts know.
Oh, okay.
Right, so that is my obligation to the courts, to notify them that I've remarried and I've got my partner living with me. What I'm trying to distinguish here is what I don't want the listeners to think that, okay, they've initiated the mediation process, that's it. They're in that process now. They have to do what the partner wants, or they have to do what they wanted to do. They can't change their mind, or they have to do what the mediators allowed them to agree. So what's the obligations there for a person?
Oh, okay. So the mediator will never force the, say, husband and wife to reach agreement. That's not what we're there for. We're there to encourage or probably explore the options to resolve the issues between them. But let's talk on the whole obligation regarding disclosure, for example, because you touched on that. So if, say, for example, the couple were in a court process, they would have to provide the court with full financial disclosure and disclosure to the other person as well. We do that within the mediation as well, because and what I mean by that is both of them, so the husband and wife, would have to give, their bank statements, pay slips, information about any debts they've got, and they would exchange that information with the other person in the mediation session, and the mediator will get a copy of that. Now, you might ask me, what's the point in doing that? Because surely they know what they've got, and isn't it just a waste of time? And you'd be surprised, and the answer is no. Actually, there is a lot of times when the husband might not necessarily know what the wife has, and vice versa. The wife might not necessarily know what the husband has. And then you've got to remember, at the end of mediation, I always say, get independent legal advice. And the beauty of mediation is that, the exchange of the information has taken place within the mediation session. And so it's done pretty instantly, whereas if you were going through solicitors, it might take several weeks for the documents to be exchanged and things. So that's probably one of the biggest obligations people have, which is to provide financial disclosure in relation to matters concerning property and finances. There's just one thing that I should add, actually, regarding children, because you talked about that earlier on in the context of grandparents. One of the other advantages of mediation is that the children can actually also be part of the mediation process, and we call that child inclusive mediation. So if, say, for example, the child is, say, not necessarily old enough, say 13, 14, but the parents agree that their child can be part of the mediation process, and the parents agree that the child has sufficient understanding, then a mediator will speak to the child on their own, and speak to the child about basically their life, isn't it? Because, the child has got these two adults who love them dearly.
Bickering over.
And sometimes the voice of the child is lost. So another advantage of mediation is that the child can be part of the process. Now, I don't want your listeners to go away thinking, oh, well, is the child going to be in the same room as me and my ex? No, that's not how it works. We see the child on their own, so long as both parents agree that the child can be part of the mediation process. We explore the options with the child, and then we give feedback to the parents as to this is what's been discussed with the child and this is what the child has been saying, because I think a lot of the times the voice of the child is probably forgotten in all of this.
Well, if it's the voices of any of my children, I'm probably glad that their voice gets lost. They'll probably do anything or say anything just to get me into trouble out of spite. So if any of my kids are listening, I do love you, and I'm only joking, as you all already know. Just a quick question regarding having a child in mediation. You said they'd be in a separate room. I take it then that there would be someone supervising the child, so that there's another third party in there as well, or would it be mediator and child only in that room?
No, the mediator and child.
Okay.
So for example, if say the parents come to a mediation and then they agree that the child can be part of the mediation, then we might say, okay, well, one of you or both of you can bring the child in, say next week as an example, and then the child will be in a room with the mediator having a conversation, whilst the parents, they might sit outside, or they might go away for like 45 minutes and then come back, but they wouldn't be in the same room as the child whilst we're having this conversation with the child.
Yeah, otherwise it just defeats the purpose, isn't it?
Well, yeah, it's a bit awkward, I guess, in some respects, because I guess the child might feel, oh, I don't want to say this because mum, I don't want to upset mum, or I don't want to say that because I don't want to upset dad, because, at the end of the day, the child loves both of their parents equally, and I'm sure the last thing the child wants to do is, say anything or do anything to hurt the other person.
Absolutely.
So that's why it's done with just the especially accredited child mediator.
Brilliant. So thank you so much for that, Dilshad. Now, we've got about 2 minutes on the clock. So before we run out of time, which I always end up doing in every single one of my shows, to all our listeners out there, you've been listening to Dilshad Miah from Family Law Mediation. If you do want to reach out to Dilshad in his capacity as an independent mediator, then his contact number is 0115 772 0299. So that's 0115 772 0299. He also has a website at www.familylawmediation.co.uk, and mediation is spelled MEDIATION. So that's www.familylawmediation.co.uk. So we've got about a minute and 40 seconds, Dilshad. So before we quickly sign off, any tips, a tip for anybody thinking of mediation, or a piece of advice that you might want to share with them if they're listening in and they're still a bit on the fence as to what they should do?
I'd say ring a mediator. If, say, for example, people contacted me at Family Law Mediation, we would have a consultation with people over the telephone. It's a no obligation telephone call. We don't charge anything for it, and we can discuss how the mediation process would work and answer any questions that people might have. I think if you're thinking about the mediation process, by all means contact a mediator, and along with that, I'd also say speak to a solicitor as well, because I think having both works best for the client, because a mediator is there to act as an independent person, whereas the solicitor would well, I don't like to use the word, but fight your corner.
Yeah. But we're there for our clients. We've got our clients' best interest at heart.
Yes.
And that's how it works, doesn't it? And it's a bit like having experts. People do forget that an expert is there. Their duty is to the courts first and foremost. They're not there for you. Whereas solicitors, they are literally there to fight your corner. We are there to make sure our clients' needs and best interests are met. But at the same time, I'm not going to bend over backwards and lie for my client, because that's something that we're not allowed to do. We can't do that. And in good conscience, we would not do that. So 7 seconds. Thank you so much for tuning in to Dilshad Miah, Family Law Mediation in Law and Action with your host, Zainab Zaeem-Sattar. Thank you very much.